Hello, friends. Welcome to the first edition of Panch Rishi Talks. And today's issue is really important. Are we heading towards a corona constitutional emergency crisis? The situation which we are facing in India is unprecedented. The situation in front of globe all over the world is unprecedented. So the question for a law student and also for people at large is, are we leading towards a constitutional emergency due to corona? Is there Is there a formula to solve this problem enshrined in the Constitution? And how Constitution and law in this country shall overcome this problem? So today's topic, to answer all these questions, today's topic is Corona Emergency under Constitution of India. Friends, this is the biggest crisis in our lifetime. We have seen so many crises, but nothing is as big as this corona pandemic. Right now, when I'm speaking to you, there are more than 1 million cases and 45,000 deaths all over the world. And the number is still increasing. If I go through India, it is more than 2,000 cases and 50 deaths. People think that it is just a medical and scientific issue. Yes, primarily it looks like, because until and unless there is not a vaccine or people do not follow strict quarantine, it is impossible to control or stop this emergency or this pandemic. But there is also other side of the coin. This problem is also raising a question in front of our law, in front of our administration authority, and in front of our constitution. Is law and order administration sufficient to manage this issue? If we see globally, the countries who have restricted corona, their law, their constitution played a very vital role. Take the example of Germany. First 1,000 cases in Germany was very fast, and from 1,000 to 2,000, they used law and order machinery and constitution to a great effect. Fortunately, in German constitution, there is a provision for emergency on the basis of health, pandemic, and endemic, and that's how they enforce it. South Korea and China, they live in a total different law and order. Of course, India cannot follow the model of China and South Korea with regard to that. जितना मैंने सुना या देखा कि अगर किसी को कोरोना अफेक्टेड है तो वो उनके बच्चों को मदर्स को बच्चों से अलग कर देते हैं, उनको क्वारंटाइन फैसिलिटी में रख देते हैं। भारत जैसे देश में जहाँ पर प्रेस इतना विजिलेंट है, जहाँ पर इतने सारे मूल अधिकार हैं जिनका सस्पेंशन आसान नहीं है, it would be difficult. See the example of Japan, how they have controlled it. So भारत में एक जो समस्या इसके साथ बहुत बड़ी हो रही है, एक तरफ हेल्थ की क्राइसिस तो है ही, दूसरी तरफ ये कहीं ना कहीं कॉन्स्टिट्यूशन एंड लॉ एंड ऑर्डर क्राइसिस को भी जन्म दे रही है। अभी आपने देखा होगा किस तरह से इतने माइग्रेंट्स जो दिल्ली से बाहर जा रहे थे, अगर उनमें से 1% को भी कोरोना है तो वो ये डिजीज हमारे गांवों तक पहुंच जाएगी। आपने देखा तफलीसी जमात का इशू, किस तरह से स्टेट उसे कंट्रोल करने में इनकॉम्पिटेंट रहा। आप ये भी देख रहे हैं कि किस तरह से डिफरेंट स्टेट और सेंटर के बीच में डिफरेंस ऑफ प्रैक्टिसिंग प्रोसीजर पाया जा रहा है। फॉर एग्जाम्पल, केरला इज गोइंग फॉर a large number of scaling and large number of testing, whereas weaker states or comparatively weaker infrastructure वाले states जितने हैं, they are going for scanning or disease detection for only those जिनको सिम्टम दिख रहे हैं। तो इन सब चीज़ों के बीच में ये बड़ा इंपॉर्टेंट हो जाता है कि किस तरह से हम इस मुद्दे को सुलझाएंगे। इस पूरी इशू में जो सबसे इम्पोर्टेंट चीज़ जानने वाली है वो ये है कि पब्लिक हेल्थ, ये विषय हमारी संविधान में लिस्ट सेकंड में है, जो कि एक स्टेट लिस्ट है, एंट्री नंबर 6, लिस्ट सेकंड 7 शेड्यूल, एंड इफ आई रीड इट राइट, इट इज अबाउट पब्लिक हेल्थ, सैनिटेशन, हॉस्पिटल एंड डिस्पेंसरीज. So health is a state subject. So only legislation which are there to be made is by the state legislature. But fortunately, there are two strong legislations there in India. One is the Epidemic Disaster Act 1897, and you guessed it right, it is 1897. It's an act which is 123-year-old. If you go through the history of this act, when bubonical plague was introduced in Bombay in 1896-97, this act was enforced to control bubonical plague. This act has only 4 sections. only two sections are really important. Section 2, which empowers state government to take action for quarantine and protection and detection. And there is also section 2A, which also empowers central government. But the authority of central government in this regard is limited, again, because health is a state subject. So it is in the hands of state to make laws and implement laws and control the issue. Another act, thankfully, we have in 2005, which is about Disaster Management Act 2005, which is working really well all over the territory in India. But again, the problems still remain the same because health is a state list subject. So we are dependent upon state laws and state machinery and state administration to control it. We have two provisions in IPC, Section 188, which calls for the violation of Public Disaster Public Management Disaster Management Act and Epidemic Disaster Act, and there is a procedure for punishment. There is also one interesting section, Section 270, which says about if somebody is in uh, spreading the infectious disease to pets, plants, or human, then it could be punished. But nonetheless, laws are incompetent, and I don't feel that it is a mistake of lawmakers because we have not thought about that massive epidemic in this country and anywhere in the world. So laws are there, but they are not as impactful as they should have been, or we were not ready for it. There is simply, we could admit it, that our legislations and laws were not ready for it. But the situation here is there a constitutional solution for it? Because throughout my law life teaching, learning, and practicing administrative law and constitutional law, I have realized this thing, that there is a possibility that whenever there is a crisis, constitution has a solution. So let's see, Constitution of India. No doubt we need policy, coordination, and administration to be centralized, to be uniform, and to be really, really strict when we talk about the enforcement and control of this pandemic to human race, and particularly in India. So many people are talking about the constitutional solutions, and the first thing which comes out in front of us is Part 18th, that is about emergency provisions. So, can emergency provision could be enforced? I would say no. Yeah, it's no. Reason being, because we have only three kind of emergency provisions. One is Article 352, which talks about proclamation of emergency. The ground is satisfaction of the president, and the ground, and to reach to that ground there has to be either war or external aggression or armed rebellion. In the actual constitution, it was not armed rebellion, it was internal disturbance. If it would have been like that, then India could have invoked Article 352, and Article 352 is a very strong instrument, because whenever there is an invocation of Article 352, Article 353 1 and 2 shall be enforced. That gives central government power to legislate and take all the executive's power of the state into their hands. There was also a provision after 352, there could also be Article 358 for the suspension of Article 19 freedom, and also 359 for the suspension of all other freedoms except Article 20 and 21. But unfortunately, or fortunately, uh, the term internal disturbance has been replaced when it was so-called misused by Indira Gandhi regime, and 44th Amendment replaced it with the term armed rebellion. So Corona pandemic is not at all an armed rebellion. So the question of Article 352 invocation is out of the picture. The next is Article 356 emergency. Now, it could only be invoked when there is a constitutional machinery failure in the state. After SR Bombay judgment, yes, physical failure of a state amounts to constitutional machinery failure, but will it solve the issue? I really doubt that, because imposition of precedent rule in all the state will take time. It has different processes, it has different checks and balances. You have to go through it and approve it through the parliament each and every time. It takes issue. There is also a question of judicial review. So I don't think that 356 is a good solution. 352 could have been a good solution, but 352 we could not enforce because the term internal disturbance is replaced by external aggression, as I have explained. Some people are talking about the financial emergency, 360. I do not think that India has reached to that level, that we do need a financial emergency. India has strong financial base, strong reserves, and both state government and central government have strong hold on money. So I don't think 360 would be applicable. If it would have been applied, then it would have been a grave emergency situation in India, particularly financial emergency. But again, finance is not an issue. The issue to control this problem is when administration is centralized, uniform, and strict. And so I don't think the three emergency provisions are the solution. So, so this is the issue. But I'm not here to raise only the issues. I'm here to answer that how constitution can cope up with that. And I have realized that whenever there is an emergency in India, constitution has extraordinary instrument to tackle that emergency. So yes, the question I asked before in the earlier part of this video is, can Indian constitution tackle this? I would say yes. Can emergency be an option? I would say no. So what are the options? So I have listed few options. I'm listing it as per the impact. So the first one has less impact, and soon as you go ahead, there will be amazing impact. These are soft solutions and hard solutions. First of all, I'll go for hard solutions. There is a provision under Article 249 when Parliament power to legislate in the respect of state list on national interest. So nothing could be more of national interest than the current situation. Parliament can legislate in the matters of state list, but we need Rajya Sabha's Anumodan. So Parliament has to come and sit, maybe with their gloves on and their masks on, they can come and sit and serve the national interest and pass the resolution so that Parliament can legislate in the matters of state list. If this option could be used, then the situation could be much more controlled, and there may be a very good uniform law to be applied all over India, particularly with respect to this endemic reaching to pandemic state. There is also an option of Article 250, but again it cannot be used because it only allows central government parliament to legislate when there is a proclamation of emergency. As far as I think, proclamation of emergency under 352 is not possible. 356 and 360 won't solve the situation. So the third option in front of us is really interesting. So that leaves us to the third option, and third option is really interesting. It is under Article 355, a duty of union to protect state against external aggression and armed rebellion. Interestingly, even 44th Amendment happened. They amended Article 352 and replaced the term internal disturbance to armed rebellion. But not in the case with Article 355. 355 still holds a duty of center to protect state in case of external aggression and internal disturbance. So that allows central government power to take actions, preventive measures, and control state in the case of internal disturbance. And nobody can doubt that situation emerging out of corona pandemic and state's inability to control it is an 100% shall 100% fall for a question of internal disturbance. There is also an option of Article 252 which allows consensual legislation, so that when state legislatures give consent to union government and parliament can legislate for them. And I don't think that state shall fall into petty politics, and I hope that state should not fall into petty politics and shall allow central government, parliament to legislate for them. There is also one option which I do not ever felt like it will be used, but there is also an option of Article 34, that is of imposition of martial law. It has never been enforced like it has been enforced in Pakistan and to an extent in Bangladesh in Khalida's regime, but I hope it will not be enforced in India and there shall not be a martial law, but it is also an option. So these are all the hard options: Article 249, Article 355, Article 252, Article 34. But there is also one hidden soft option that I kept it for the last, and this is a wonderful tricky option. It is there in list third, and I mean list third means concurrent list, in which state legislature and parliament both can legislate, and if there is a parliamentary legislation, then parliamentary legislation shall prevail over the state legislation. It is in list third, entry number 29, which says that when there is an infectious disease spreading into states with respect to pets, animals and human beings, Parliament can legislate. So this option is wonderfully available and you do not need to take an extraordinary means. I hope central government listens to me and uses this option if we need a uniform, strict, centralized law to control this corona pandemic. So there are options in the constitution, there are soft options in the constitution, there are hard options in the constitution, and once again constitution is there for the rescue. So people who are saying that Indian administration and Indian government and Indian laws are unable to control that, they should read the constitution again, and everybody should read the constitution. Even our lawmakers should read the constitution, and there is a solution for this maladministration that is happening due to corona crisis, and I hope it will be over. So doctors are doing their jobs, lawyers and law students and law professors should do their job and research and put out the options which are available to state, central government, parliament, to do all kind of measures to control it. Of course, it is unprecedented. It is biggest human crisis in our lifetime, and I hope it would be the last. We are ready to control it, and we shall control it. And I believe, as I have always said, that I believe in a hope, and hope is coming right from the Constitution. Thank you. Please do like, subscribe, and comment. Thank you.